The Paris Workshop of 1991, at which the Paris Principles were negotiated and adopted, reflected the broad composition of participants. A national institution must be a body, an authority, or an organization performing general and specific functions in the protection and promotion of human rights. But what happens when someone with considerable state power delivers a consistent flow of propaganda to a national human rights institution to instill fear, as we've seen during the McCarthy era? Much like Joseph McCarthy, an andric, hypercritical, fogyish body has created hysteria in Northern Ireland about the alleged risks that Jewish people and Black Americans pose to this Belfast community. But this episode is not entirely about that. What I seek to understand is whether the Northern Ireland Human Rights Commission has signed an oath of loyalty, and if so, to whom? I'm Kiana Canada, and this is Mimicking McCarthyism, an examination of an obstruction of justice, uncovering a new iteration of McCarthyism in Belfast, and how it silences Black American stories on the island. Some of you out there may wonder, like I once did, as to whether the Northern Ireland Human Rights Commission is an NGO or state body. My research on this question led me to the United Nations, who explained in their documents that national human rights institutions are state bodies with a constitutional and or legislative mandate to protect and promote human rights. As a state institution, the Northern Ireland Human Rights Commission is fundamentally different from an NGO because it is part of the official governance structure of the state. Building on this idea, the Commission fundamentally has strengths that NGOs just do not have. For instance, it has greater authority than an organization like Exani, deriving from their official status. This gives the Commission more influence in its domestic and international forums. It is also worth mentioning here that its recommendations and opinions have more credibility and influence than an NGO, which makes it an ideal conduit for exposing state crimes. As mentioned in previous episodes, the Commission has stronger investigative powers, which allows it to obtain documents, summon witnesses, and to enter premises. This fact will become particularly relevant in the next few weeks after this series has concluded. Now, ladies and gentlemen, I do not argue the Commission in Belfast is not limited in some capacity. The Commission cannot do whatever their members decide that they want to do or should do. It also does not enjoy the same freedoms as some NGOs. First, they are statutorily bound by the laws in Northern Ireland. This means the Commission in Belfast must promote and protect the human rights of everyone. Second, they must also act independently of all external direction or influence. This, of course, does not apply if a court hands down a judgment that is contrary to the position of the Commission. Third, the Commission has the power to advise Parliament on human rights issues, which includes individual cases or what they found to be a pattern of human rights violations. So, why isn't the Commission in Belfast doing this? More importantly, is it limiting who it represents? It is true the Commission in Belfast has complained of budget restraints. However, one cannot close their eyes to the fact that the Commission receives grants from international donors and philanthropic organizations and foundations. It is also funded under the state budget. Could this perhaps be the reason why it has narrowed its mandate? Does any of its inactions have to do with taking a loyalty oath? If so, to whom? To reiterate, the Commission has the jurisdiction to receive and investigate individual complaints, which also gives them the power to make binding, enforceable determinations on those complaints. So, why hasn't it done so? Perhaps the mere fact that no consequences will come if it doesn't is the answer. A better question is, how does the Commission maintain a grade A status when it has failed to comply with the Paris Principles? To answer this question, we may need to go deep. And in this episode, we'll swim down just a few feet. Alison Kilpatrick took a post at the Commission on September 1st, 2021. She is also a Bureau member of the Global Alliance of National Human Rights Institutions. Under Article 46, Kilpatrick, along with other Bureau members, have the power to decide applications for accreditation. At the time of this broadcast, all 14 member states have a grade A status. This includes a country that was recently at the center of much controversy last year. In 2023, the UK and the government of Rwanda signed a treaty to transfer some asylum seekers in the UK to the African nation. Despite Rwanda arguing it had a strong history of providing protection to those who need it, hosting over 135,000 refugees and asylum seekers who have found safety and sanctuary there, the Northern Ireland Human Rights Commission argued in its advice on the safety of Rwanda asylum and immigration bill that the African nation had a poor human rights record. Other organizations followed suit. When the case traveled up to the Supreme Court, it identified a range of factors, including well-evidenced shortcomings in Rwanda's compliance with its international human rights obligations. If Rwanda has a poor human rights record with institutions that are not independent and has failed to comply with international human rights obligations, how does its human rights institution maintain a grade A status? Is it possible for a human rights institution to be 100% committed to human rights within a country that has a documented history of not protecting human rights? I must clarify here that I'm not singling out Rwanda or any other nation. In fact, I'm a bit suspicious and skeptical of the human rights grading of other Bureau members as well. But something is not adding up here. The math just ain't mathin'. To be sure, the grade A status means fully compliant with the Paris Principles. Under the Paris Principles, a national human rights institution must be independent of the government. Yet the Commission found Rwanda lacked an independent legal system. If no independent legal system, then it's not fully compliant with the Paris Principles. If not fully compliant with the Paris Principles, then how does it maintain a grade A status? What concerns me here is how states, including my own, have the power to stack institutions so as not to be held accountable. But let's refer back to the Commission. Here we see Northern Ireland is represented in the Global Alliance of National Human Rights Institutions. The mandate holder for the European Commissioner of Human Rights is Michael O'Flaherty. Sorry if I'm butchering that name, who has allegiance to Northern Ireland. Further, the Special Rapporteur on Human Rights Defenders is Mary Lawler, who has chosen to remain silent on the Republic of Ireland's perpetration of transnational repression. Now, I concede, states that are supposed to be represented in international human rights institutions, they are supposed to be like the Olympic of human rights. But when a country is participating in the race and sits as the only referee over the race, now we're just talking about card stacking. In other words, human rights institutions have played a significant role in stacking the cards against the truth. The Northern Ireland Human Rights Commission, in the words of Robert Jackal, quote, created a smokescreen of clamor, end quote, by focusing on other issues so that we could forget that transnational repression is occurring on the island. This raises a question as to whether such institutions act as gatekeepers, preventing complaints from reaching independent human rights panels. As with McCarthyism, card stacking produces sham, hypocrisy, and impertinent institutional behavior. In episode 20, I'll reveal who I definitively believe is behind the McCarthyism occurring in Belfast. We'll see you next time.